Well, another big day in the court in the double murder trial of Alex Murdaugh. In addition to the testimony of two prosecution witnesses, there was an important evidentiary ruling by the judge that is likely to hurt Murdaugh's defense. Let's bring in criminal defense attorney and federal litigator Vic Bajaj. Vic, it's always great to have you on. You know, I look at this whole thing and I think I can't quite wrap my mind around how all these financial crimes getting in and getting to the jury is such a detrimental thing for the defense.
Well, anytime you talk about a financial crime, what you're really saying is the person you're talking about is a thief and cannot be trusted. And even though the Judge Newman in this case said you can only consider it for motive, because this is a circumstantial case, consider it for motive but nothing else, that's an academic exercise, Trace. You can't have the jury unthink or unlisten or not consider something for one portion of their calculus and not the other. Now, if we're in law school, we say the judge made the right ruling, but this is a bombshell and a real defeat for the defense.
Because even if you only use it for motive, when you lay out all these financial crimes, it looks like an interesting motive.
Absolutely. And you just think to yourself, can it really be that simple? Can you really think a suspect and a defendant would off his wife and his 22-year-old son just to distract from the attention of his thieving and his crimes? But in this case, the prosecution believes it is, in fact, that simple, and jury is now entitled to consider it.
We saw one of the family caregivers on the stand. David Lee Miller showed her a little bit ago, or Michelle Smith is her name. And there is this theory that, Alex Murdaugh tried to use her as an alibi to get her to lie. Listen to her and we'll get your response.
Did Alex Murdaugh ask you to tell somebody how long he'd been there?
He said, someone asked you, I've been 30 to 40 minutes. That's what he said.
And she went on to say he wasn't there that long. He wasn't there 30 to 40 minutes. That's a big deal.
It is. I mean, we have hundreds of charges, dozens of charges in unrelated trials that he's going to be facing, the financial crimes, the embezzlement, etc. Well, that's dissuading a witness. He knew at that point in time, a few days after the slaughter of his family, that a serious crime and a serious investigation took place. Now, what you don't want to see as a defense attorney is tears and real emotion, because every jury instruction throughout the union says you're entitled to entertain a witness's demeanor. And she was telling the truth, and he was doing his darndest to make sure she wasn't going to continue to do that.
But when she comes out and says, he asked me to lie, if you're a defense attorney, you've got to be fast on your feet to try and get over that.
That's exactly right, or you wear a purple tie the next day to distract from that fact. There's very little you can do to take away that shine.
Yeah, I want to move on, if I can, quickly to the Alec Baldwin trial, because it starts the 24th, the prelim of this month. And a few weeks ago, we know Alec Baldwin, the charges all filed, but a witness list has now been released, and it includes the following here: director Joel Souza, who was shot on the movie set, camera assistant Lane Looper, gaffer Serge Svetnoy. During a press conference months after the shooting, Svetnoy's attorney told reporters that the movie's producers were cutting too many corners to save money, and that negligence on set led to Hutchins' death. They're trying to build this negligence case.
Absolutely. It's just like building a house. When you have negligence, the most important piece of evidence you need to combat as a defense attorney and you need to promote as a prosecutor is, have you done this before? Has the suspect engaged in reckless behavior before? Something that touches all of us, unfortunately, are vehicular homicides. They're involuntary homicides.
Yeah.
Well, have you seen the defendant in that case drive recklessly before? Drive under the influence before? All of that goes to build a house of recklessness and negligence, which is the required state of mind for these offenses in New Mexico.
I got 20 seconds left. This is in the Brian Kohberger case, the Idaho murders. The neighbor says this, quoting, "At one point during the 4 days he was surveilled by the FBI. Prior to his arrest, Kohberger was observed putting trash from his family's house into the neighbor's garage bins around 4 a.m. Why are you getting rid of your trash, Brian Kohberger?
For the prosecution, a suspect's trash is a prosecution's treasure in this case, and it's not only evidence of premeditation with the receipts from Walmart, with evidence that was used in the commission of the crime, but also covering up your trash shows consciousness of guilt, and that's what the prosecution's after.
Vic Bajaj, thank you for coming on.
My pleasure. Thank you.